Okay, let's unpack this idea. For centuries, we've talked about the gold standard in governance being the rule of law.
Right.
Not one person calling the shots, not the executive branch running everything, but the law itself. Enforced by judges who are, well, completely independent, totally impartial.
Exactly. And when we think about where that standard comes from,
Mm.
the usual suspects pop up: classical philosophy, maybe the Enlightenment in Europe.
Right.
But what if I told you that those very principles,
Mm.
the law being supreme, judges being independent, appointing them based on merit, uh, even assuming innocence until proven guilty, what if they were already worked out,
Mm.
systematized, put into practice centuries earlier,
Yeah,
like
yeah.
as the actual blueprint for a whole society?
That's the historical puzzle we're digging into today, isn't
That
it?
really is a paradox.
Welcome back, everyone, to the deep dive. So you, our listener, you've given us this really fascinating and pretty dense set of materials. It draws specifically from Zahir Ahmad Mir's work on the legal history of the prophetic legal order back in Medina.
Hmm.
We're really zooming in on the structure of governance during that period, focusing on cases 16 through 23. These cases seem to lay out the structural engineering behind an independent judiciary.
Yeah, and our mission today, it's more than just recounting history. We're trying to pull out the core mechanisms. How did this system of what Mir calls prophetic justice actually work? How was that separation of powers achieved? How were ethical standards kept high? And how were individual rights, things like due process, actually protected in a systematic way?
It sounds like advanced political science almost,
Yeah.
legal philosophy, but wrapped up in history.
That's a good way to put it.
Okay, so we've got four main themes lined up. First, those foundational ideas about separating powers. Second, how they actually built the judiciary meritocracy, inclusion. Third, the ethics side, integrity, transparency, making sure things were visible.
Right.
And finally, maybe the most crucial part for many people today, protecting individual rights against the power of the state.
Due process.
Exactly. So let's not hang about. Let's jump straight into what feels like the most, well, radical idea in this whole source. The head of state actually having to obey the courts. All right, case 16. The source labels this the establishment of a radical separation of powers. Expert. The core idea is pretty clear. Courts need to be structurally separate from the executive. But to really feel the impact of that, we need to see how it played out in practice.
Indeed. And this wasn't just, a nice idea written down somewhere. It was tested, and the ultimate test. The Prophet Muhammad himself. He accepted rulings from the judiciary that bound him, rulings that actually constrained what he could do as the executive leader.
Wow.
That single fact, historically speaking,
Right.
it's like the bedrock of constitutional theory.
Okay, let's pause here because the context is just so important. Think about that time. You look around the world, the Byzantines, the Sasanian Persians, various kingdoms. The ruler was the law. Sovereignty was in the person, the emperor, the king. If you challenged the ruler, you were challenging the law itself. And the consequences were usually, well, pretty final, swift and fatal.
Correct. So when the prophet submits to a court ruling, maybe one that even goes against what he'd prefer or what's politically convenient, he's basically setting a revolutionary precedent. He's saying sovereignty doesn't live in me, the executive. It lives in the law, in this case, divine law.
That act of submission, it shows everyone, even the highest political authority, is accountable, stands under the law, just like everyone else.
It draws the line,
Right.
functionally. If the judiciary can rule against the top executive, and that ruling sticks, it's implemented, no challenges, no overriding it, then you've got real operational judicial independence.
It's the essential condition, isn't it, for a system where the rule of law actually wins out over the rule of whoever happens to be in charge.
And think about the long term. This wasn't just a one-off gesture. It's a structural design choice. It immediately puts executive power underneath the judicial branch. It means any future leader, any caliph coming after, knows the same rule applies to them.
It creates a kind of institutional inertia pushing towards judicial independence. You'd have to completely break the whole legal order to undermine it later.
Exactly. It's a brilliant piece of constitutional engineering, really, designed for stability across generations.
Okay, so that covers the vertical separation, the top boss and the courts. But systems grow, right? Power gets spread out. How does this authority work when it's distributed geographically? That takes us to case 17. Delegated authority and its strict boundaries.
Yeah, that's always the challenge for an expanding state. Delegation. You grow, you have to give judicial power, administrative power to governors, local judges out in the
And
provinces.
the risk is always that these distant officials become little tyrants, right? Operating outside the law just because they're far from the center. History's full of examples.
Precisely. But the source material points out the specific constraint used here to prevent that kind of executive overreach. It wasn't just a suggestion to be good.
No, it says the delegated judicial powers were explicitly and strictly bound. Bound by what?
Why the Quran and the Sunnah. And that detail is crucial. It essentially codifies the limits. The Quran lays out the core legal framework, the principles. The Sunnah, that's the record of the Prophet's own judgments, the precedents he set that acts like the primary source for how to actually do things, procedural law, interpretation.
So by tying that local delegated authority directly to these supreme legal texts.
The system ensured justice was systematic, consistent. A local judge or governor couldn't just impose their own personal whim or some local custom if it clashed with those central texts.
That sounds like a very old but actually quite sophisticated form of checks and balances, keeping local administration from going rogue.
It builds in accountability. Think about it. If someone challenges a local judicial decision, what's the standard for review? It's not, what did the governor think? It's, did the ruling line up with the fixed legal texts?
Right.
It basically tells the governor, you're not the source of the law here. You're just the appointed administrator of the supreme law. That mechanism stops decentralization from becoming fragmentation. It keeps the rule of law coherent, even across big distances.
Okay, that makes sense. So Case 16 gives the judiciary independence from the top leader.
Yeah.
Case 17 locks its procedures into dependence on the supreme law itself. A tight system, non-arbitrary.
Exactly. A framework designed for consistent justice delivery. But, having a great structure on paper isn't enough if the people running it are incompetent. Or worse, corruptible.
Right. Which brings us to the next logical step, staffing the judiciary. How do you pick the judges?
And that's Case 18. Merit-based judicial appointments. The principle here, honestly, it sounds incredibly modern. Selection based purely on competence, knowledge, intellectual ability, not on your social status, how much money you had, or, crucially, your family or tribe.
That last part, overriding lineage, that must have been genuinely radical in a tribal society.
Oh, absolutely. Traditionally, your lineage dictated your power, your honor. To say, no, for judges, we only care about how smart you are, how much you know.
Yeah.
That's creating a functional aristocracy of intellect, replacing the old aristocracy of birth, at least in this critical function.
But let's push on this a bit. It's easy to say meritocracy. It's much harder to actually make it happen when you've got political pressures, powerful families wanting their guy in place, economic interests.
Right.
How did they genuinely uphold this standard?
Well, we see the mechanism, or at least a strong example of it, in that famous story about appointing Mu'adh ibn Jabal, peace be upon him, as a judge in Yemen. The conversation during his selection wasn't just about, does he know the texts? It was also about his ability to reason independently, his capacity for ijtihad.
Ah, independent reasoning. That's the key detail, isn't it?
Precisely. It wasn't enough to just memorize the law. You had to show you could apply it correctly to new situations that maybe weren't explicitly covered.
So the Prophet actually asked Mu'adh, what will you do if you don't find a direct answer in the Quran or the Sunnah?
Yes. And Mu'adh's response was that he would exert his own reasoning, ijtihad. That confirmed it.
So merit wasn't just book knowledge, it was complex problem-solving skills, ethical judgment.
Exactly.
Yeah.
It sets the professional bar incredibly high. You're not just hiring clerks or scribes. You're picking intellectually capable jurists. It's the historical ancestor, in a way, of things like modern judicial service commissions bodies designed to filter out the political noise and ensure the quality of judicial decision-making.
And the payoff. If you choose judges based purely on their qualifications, you get deeper public trust in the whole system.
Absolutely. Because people believe the outcomes are driven by expertise, not by politics or connections.
That kind of appointment system signals long-term stability. If the public thinks the judges are genuinely the smartest, most knowledgeable people around for that job, they're much more likely to accept rulings, even the difficult ones.
Couldn't agree more.
Okay, so you've got structural integrity, you've got merit on the bench. But what about access? Does this independent, high-quality system actually serve everyone? That leads us to Case 19, inclusive communal representation in justice.
Right. Because an independent court system doesn't mean much if only certain people can actually use it. The core idea here is access. Justice has to be available to all groups in society, regardless of their social standing, their wealth, or, importantly, their religion.
And the source material gives this, well, pretty stunning example.
Hmm.
Non-Muslims living within the state were explicitly allowed, even encouraged, it seems, to bring their cases to the central court.
Think about that. They weren't just shuffled off to some secondary separate system based on their own faith or community identity.
That says something profound about how this legal system saw itself, doesn't it?
It's making a universalist claim. It's saying, our law applies equally to everyone living under our political authority. If you're subject to the state's power, you must also have equal access to its system of justice. No distinctions based on community affiliation.
From a state-building perspective, that's incredibly smart for promoting stability.
Of course. By giving non-Muslim communities equal procedural rights, equal access to the highest court, you secure their loyalty. You encourage peaceful integration. They know they have a reliable way to settle disputes, whether amongst themselves or critically if they have a grievance against a state official.
It takes the idea of justice beyond just religious or ethnic boundaries. It really establishes a historical precedent for universal access to justice, something many modern countries still grapple with.
It proved the system was designed at its core to be impartial, to see the person before the court simply as a subject of the law, not as a member of Group A or Group B who might face built-in bias.
So independence from the top, coherence down at the local level, merit selecting the judges, and universal access for everyone living there. That's a powerful foundation they were building.
A very powerful construction indeed.
Okay, so we've talked about the structure of power, how it's set up, who gets appointed, who gets access. Now we need to shift to the ethics of actually using that power because, like you said, the best structure in the world can crumble if the people inside it lack integrity.
Exactly. And that brings us straight to Case 20. Comprehensive ethical standards for public officials. This isn't just about judges, but all public officials involved in the justice system. It enforces a really strict, non-negotiable ethical code. Why? Because public trust is everything. It's the system's most valuable currency.
And the source really zeroes in on the biggest threat to that trust, doesn't it? Corruption, specifically bribery.
Yes, it details a strict prohibition on bribery, but it goes way beyond just saying it's illegal. It's not just about legal punishment.
How so? What makes it stronger?
The strength comes from the specific language used, the condemnation cited in the source material. It quotes the exact phrase. The curse of Allah is on the briber and the bribed.
Right. The curse of Allah. That elevates it, doesn't it?
Massively. A legal ban might mean a fine, maybe jail time, but a divine curse. That means the offense isn't just a crime against the state, it's a crime against the entire moral and, well, cosmological order.
It puts the fear of God into it, quite literally.
It creates an environment of absolute zero tolerance. Any official involved knows that taking a bribe isn't just risking their job or earthly punishment, it's risking spiritual ruin. That makes the judicial oath something far more profound than just a political agreement.
It's weaponizing moral authority, in a sense, to protect the institution's integrity.
And for a public official, especially in that historical context where maybe centralized enforcement could be tricky over vast distances, that kind of moral deterrent is arguably much more powerful than just a legal penalty.
Yeah, you can see that. And this tough stance on bribery, it's fundamental for keeping society stable, isn't it? The second people think the courts can be bought.
The whole system collapses. People lose faith. They stop using the legal channels. They might turn to violence or feuds or other ways to settle scores. So fighting bribery isn't just about clean government. It's about preserving peace.
It also sets expectations for the public. If everyone knows this is the standard and an official is caught taking a bribe, the outrage is universal. It's not a political issue, it's a moral one.
Exactly. And that strengthens enforcement because the whole community feels invested in upholding the integrity of their judges.
Okay, so that's the internal ethics covered. What about the external view? How do you ensure people can see that the system is working properly? That leads us to Case 21, transparency and public access to information.
Right. The core idea here is simple but profound. Justice can't hide in the shadows. Secrecy just breeds suspicion. And suspicion undermines that legitimacy we were just talking about, the legitimacy that the zero-tolerance policy on corruption is trying to build.
So justice needs to be done openly, visibly.
And the procedural example given is pretty straightforward. Court sessions were often held in public. Verdicts were announced openly. But let's dig into the why. What's the functional reason for making visibility mandatory?
I suppose if everyone's watching.
Exactly.
Yeah.
Transparency acts like a disinfectant. If a judge knows that the whole community, the person accusing, the person accused, their families, impartial observers, is right there watching the process,
They're instantly more careful, right? Incentivized to follow the rules properly, avoid any obvious bias, make sure their reasoning is solid and clearly explained.
it creates real-time public scrutiny. The community itself becomes a witness, not just to the outcome, but to the fairness of how that outcome was reached. This practice connects directly to modern ideas like open courts, freedom of information laws.
It confirms that transparency isn't some optional extra or a favor the court does for the public. It's a fundamental structural requirement for accountability.
And there's another benefit. When verdicts are announced publicly, it has an educational effect. People learn what the law actually says, how it gets interpreted in real cases, what the consequences are for different actions.
So it increases legal literacy across the board.
Yes, which in turn strengthens the rule of law itself. It demystifies the whole court process, makes the law feel knowable and predictable for ordinary citizens.
Okay, so you've got high ethical standards backed by serious moral weight, combined with mandatory public visibility. That sounds like a judicial system designed to be both internally clean and externally verifiable.
A very robust combination.
Yeah.
And now we get to the part that, for many people today, really defines whether a society is free or not. The mechanisms the system builds in to protect the individual citizen,
Sure.
specifically protection from arbitrary state power.
Yes, the core of due process. This starts with Case 22, individual rights and state limitations. This one seems focused on shielding people from arbitrary punishment, making sure the state, its agents, police, whatever, are strictly limited in how they can accuse someone and find them guilty.
And that limitation isn't just a nice thought. It's procedural. It's built into the rules of evidence. And this is where we find that absolutely critical legal declaration, the one that forms the bedrock of the presumption of innocence.
Right, the source highlights that specific legal maxim declared by the prophet himself. The burden of proof is on the claimant.
Such a simple phrase, isn't it? But think about the power packed into those words. It's arguably the strongest possible defense against potential state abuse. Let's just unpack what that means in practice.
Okay.
If the state is the one making the accusation, the claimant, then the state carries the entire burden. They have to bring forward compelling evidence, rigorous evidence, verifiable evidence, the person accused. They don't have to prove anything. They don't need to prove they're innocent.
Wow. So under that structure, just arresting someone arbitrarily or having an official declare someone guilty by decree, basically impossible, legally speaking.
It shouldn't happen. If you're arrested, the government's immediate job isn't to force a confession out of you or rely on the status of whoever made the accusation. Their job is to start gathering proof, solid proof.
It demands rigorous investigation then. Careful police work, reliable witnesses, actual material evidence.
Absolutely. And if the state can't meet that burden of proof, their case just collapses. That single maxim implicitly grants several rights we think of as modern. The right to remain silent, protection against being forced to incriminate yourself, the right to challenge the evidence the accuser brings forward.
You know, when we talk about due process today, things like facing your accuser, the need for evidence, we often trace those back to Magna Carta, maybe later developments. But seeing this principle, the burden of proof resting squarely on the accuser established and operational centuries before that, it forces a pretty major rethink of the timelines in legal history, doesn't it? Especially regarding individual liberty.
It really does. It's a profound institutional safeguard built into the system right from the beginning.
It shifts the whole power dynamic away from the citizen being vulnerable and towards the authority having the responsibility. The default position is innocence, and that legal presumption can only be overturned by evidence meeting a high standard.
That is fundamentally the operational definition of a society governed by law, not by fear.
Okay, so that protects the individual during the process. What about ensuring the quality of the final decision?
That brings us to the last case here, case 23, which looks at shura, consultation, in judicial decision-making.
Right, because even with the best intentions, a single judge can make a mistake, especially in a tricky case. Maybe the situation is totally new, no clear precedent. Maybe the evidence is conflicting or ambiguous. The risk of one person getting the interpretation wrong is real.
So the principle of shura, or consultation, comes in, the idea being that collective reasoning makes the outcome fairer and more accurate. Exactly. And the source points out that the prophet himself used this approach. He would often consult with his knowledgeable companions who were essentially the legal experts, the jurists of that time, before he delivered rulings in complex cases.
And this wasn't just asking random people their opinion, was it? It was targeted consultation with experts.
Precisely. It's an act of, well, judicial humility and intellectual rigor. The judge acknowledges, maybe I don't see all the angles here. So they seek out diverse legal perspectives. They test their potential interpretations. They make sure their application of the supreme law fits the specific facts.
It ensures the final verdict isn't just one person's potentially flawed view, but reflects a more sophisticated collective understanding of the law among the experts.
Yes, and think about the parallels today. This practice is a direct ancestor of our modern judicial panels. Appellate courts hearing cases with multiple judges, even on bond hearings where a whole court sits together.
It's institutionalizing peer review, right, within the decision-making process itself to catch errors before they happen.
And it adds legitimacy, especially to those difficult, complex rulings. People are more likely to accept a tough decision if they know it wasn't just one judge's call, but came from a consensus among the most qualified legal minds available.
It also helps prevent bad precedents from being set.
Good point. By vetting the decision through multiple experts, the court increases the chances that the ruling will hold up, be sustainable, and applied coherently in similar future cases. It adds to the overall consistency of the law over time.
So you have the ultimate protection for the individual innocent until proven guilty by the accuser, and then an internal mechanism to double-check the quality and accuracy of the final judgment itself. That really does feel like a complete legal infrastructure.
Remarkably so. Hashtag tag recap and synthesis.
Wow. We've covered a huge amount of ground here across these 8 specific cases, 16 through 23. We've seen how they built judicial independence, meritocracy, ethical codes, due process, how it all fits together. Let's try and quickly pull those main threads together for you listening.
Yeah, that's crucial, because the real power of this system isn't just in the individual pieces, it's how they combine, the synthesis.
Okay, so we started with that foundational structure. 1, judicial independence from rulers. That was case 16. Even the head of state had to obey the law. 2, delegated authority had clear boundaries. Case 17. Local judges weren't free agents. They were strictly tied to the supreme legal texts, the Quran and Sunnah. No arbitrary rule out in the provinces.
Then we move to the people involved. 3, appointments based on merit. Case 18. Competence and knowledge trumped everything else, like family or money. We saw that with Mu'atim Jabal. 4, inclusive justice, open to everyone. Case 19. Muslims, non-Muslims, everyone had access to the courts. That was key for community stability.
Right. And then those crucial guardrails for integrity. 5, strict ethical codes. Case 20. Especially that zero-tolerance stance on bribery, backed by that really strong moral condemnation, the curse of Allah. 6, transparency and public access. Case 21, open courts, public verdicts, making sure justice was seen to be done, which deters bad behavior and also educates the public.
And finally, protecting the individual, the bedrock of liberty. 7, citizens' rights actively protected. Case 22, anchored in that fundamental rule. The burden of proof is always on the accuser, innocent until proven guilty. 7, citizens' rights actively protected. Case 22, anchored in that fundamental rule. 8, collective consultation for better rulings. Case 23, using shura, expert deliberation, to minimize errors and make complex judgments more robust and legally sound.
So you put all that together, the structure, the personnel, the ethics, the individual protections, it's this incredibly comprehensive legal framework. And it forces us to confront that timeline issue again. The source material sums it up, saying this system represented the rule of law at its highest standard.
And that, I think, is the core takeaway for you, the listener. Usually when we talk about the history of checks on executive power, limiting rulers, where do we look? Maybe Magna Carta in the 13th century, limiting the English king's power over his barons. Yeah. Or we jump forward centuries to Enlightenment thinkers like Locke or Montesquieu talking about separating powers.
Yeah, that's the standard narrative.
Yet here, in 7th century Arabia, we have documented evidence of a fully working, intentionally designed system featuring judicial independence and the presumption of innocence ideas we consider absolute cornerstones of modern liberty. And it wasn't just theory, it was operational.
It wasn't an accident. It looks like clear, advanced constitutional thinking being put into practice.
It makes you ask why. Why did this legal structure develop in this specific way so early? I think the answer lies in the system's primary goal, to embody justice, adl. And real justice, if you think about it, has to be non-arbitrary. It needs to be knowable, predictable, applied equally to everyone under its authority.
And that fundamental intention naturally leads you to principles like meritocracy for judges and placing the burden of proof on the accuser.
Because those are the practical tools you need to achieve impartiality. They're how you make justice real.
So the lesson here seems to be that these core principles of good, stable governance, they aren't owned by any one culture or time period. They tend to emerge wherever a society genuinely prioritizes justice and stability over just raw political power.
Well said. The complexity and foresight shown in these cases, documented so early, is powerful proof of that historical reality. Hashtag tag outro.
So we've looked at systems for appointing judges, enforcing ethics, protecting individual rights, building in structural checks on power. It really is comprehensive, rigorous, and remarkably well documented for its time.
And the implications for how we think about governance today are pretty profound. If we measure the health of any political system by how independent and fair its judiciary is, well, this historical example gives us a very clear, very high-resolution benchmark, a mirror we can hold up to our own modern institutions.
Yeah. So we want to leave you with this final thought, something that really underpins all the source material we've discussed today. Justice isn't just some procedural thing, a series of court dates and legal filings. It's presented here as the very soul of civilization.
That's the essence. A society that successfully engineers independence, integrity, and due process into its legal system is building for the long haul. It's securing its future. Conversely, a society that lets those structures weaken or decay, it's always eventually heading towards instability, dissolution even.
So the question for you is, what will you look for now when you examine systems of governance your own or others around the world, knowing that these complex, comprehensive precedents existed centuries ago? Do the legal systems you see today actually meet those high standards of independence, of individual protection that were established back then?
It provides a powerful lens, doesn't it, for evaluating the real integrity, the true legitimacy of any modern nation state.
It certainly does. Thank you for joining us for this deep dive into prophetic justice. We'll be back soon to continue exploring these fascinating intersections of governance, history, and ethics.